Now let's talk about the good stuff. Let's talk about keeping the house instead of letting it go, because I'm sure that's why you're here. You're not here to say, let's go in the default strategy. Let's go to the good strategy first, okay? There are many, many ways of keeping your house, all right? Now I'm going to talk primarily about the foreclosure defense and the bankruptcy. The other three, the modification, the refinance, and the forbearance, and especially the modification, Caroline is going to come and talk to you in great detail about that process. And we love modifications. Modifications is a great thing right now, if it's done correctly. And we've had many of our clients who've had their payments dropped dramatically as a result of the modification. So that's one of our first thing we're thinking when someone comes to the foreclosure problem with us, okay? But we're going to let her talk about that. The forbearance, that essentially means that you're a little bit behind in your payments. Maybe you had some temporary job loss, maybe a month or two. You got a job back again. You got income coming in. You're only 2 or 3 months behind. Maybe it's just a repayment plan. That's what the forbearance is. It's like payment and a half. You get $1,000 payments, but you're paying $1,500 a month, and you're catching up. That's kind of what the forbearance is. Versus the modification, which is actually changing the terms of the note itself, changing the interest rate, changing the duration, maybe changing the principal amount due on the note. That's what the modification is. That's the difference between those. And then there's a refinance, which I'm not going to address. Refinance is great, but most of the people that I see, it's not an option. Either because there's zero equity and way upside down, or because they're just too far behind on payments at that point. But it is an option for, and again, for some people, that is an option, okay? So I throw that up there just for, but let's talk about the real stuff. Foreclosure defense. Now, we talked before about this. You get 20 to 30 days. It's really 20 in the rules of civil procedure, but some mortgage companies will say you get 30. And so 20 to 30 days, depending on what it says in the complaint, to file an answer, a responsive pleading, okay? Now, why do you want to do that? Well, first of all, it allows you to be in the game. You get the invitation to the dance, and if you don't RSVP, you don't get to go, okay? Which means that you don't get to raise defenses that you do have. You don't get to participate. You don't get to receive notice. Here's my biggest fear for many, and this has happened to several of my clients. The sheriff shows up at their house with the 24-hour eviction notice. What? What? It turns out their house was sold a week earlier at a foreclosure sale. They never got any notice because they never filed a responsive pleading. Once you do that, you don't have to get notice. You're out of the game. Now, sometimes they'll do it anyway, but very often they won't. And so you have no idea that that motion for summary judgment is being heard. You have no idea that the sale has been scheduled, and you have no idea that the eviction notice is coming, okay? And there's nothing worse, I guarantee you, than having this 24-hour notice in a 4 or 5 bedroom house that you've been living in for 20 years. It's not doable, okay? And if they want to be mean about it, they can bring a gang of guys over and throw your stuff out in the front yard, and they will do that. If you've ever seen, sometimes every once in a while I'll drive around and I see there's a bunch of stuff out in the front yard. I know what happened. That's what happened, okay? And now, if you get one of those things, call the mortgage company, call the attorneys and say, please, I had no idea. I need extra time. They just as soon move you out in a nice way than have them come out, because then you're going to destroy stuff, and it's not pretty, okay? But that's what happens if you don't file a responsive pleading, okay? So please, even if it's a 1 sentence, I want to pay, it's something, okay? And then the final thing is it gives you a right to mediation. And this is something relatively new as far as foreclosure goes. Traditionally, you never had a right to mediation, but the response of the judges around the country, and in Florida in particular, and in Orlando in particular, has been, we want to give people the right to at least be heard and at least get to talk to the mortgage company, because you can't talk to them a lot of times. I do this for a living, and I can't get a hold of them. I have to go through 14 people to get to someone who can actually say something, and it's frustrating. And that's saying I'm an attorney. Normally it at least gets me a phone call, but a lot of times it's not. So the mediation is the judge's response to the mortgage company is not responding, and this makes them talk to you with a mediator. You have to have someone there. We're going to talk a little bit about that. But if you don't file a responsive pleading, you don't get to participate in mediation either. You get nothing, okay? So remember that. If that complaint comes, do something with it, okay? Next slide. Legal defenses. All right. People all the time, when I ask them, why didn't you answer the complaint? Why didn't you talk to an attorney? Why didn't you do something when that complaint came? Well, I didn't make the payments. Okay. You know, I owe the money. I get that. I know you didn't. I know you owe the money. But that doesn't necessarily mean that they have the right to throw you out the way that they are. Okay? There are many, many, many defenses to foreclosures. And I'm going to just throw you the big ones now, just so you can get a sense for that. I'm not trying to teach you about the law. I just want you to see that there are options, okay? Now, the biggest one, there's really two big ones that I see. What we call standing, which means that they have the right to sue you. You'd be amazed that the bank would serve you with a complaint, but you know what? They don't legally have the right to sue you. And you're going to say, well, how's that? Well, I'm going to show you, all right? And the other one, and this is kind of a big thing in the media right now, which is why I threw it out there, is the lost note defense. And you've probably heard about this. This is a big deal right now. And I'm going to talk a little bit about that, but it kind of sort of goes hand in hand with the problems. But there are defenses. All right, let's go to the next slide. Hopefully you can see this. This is in your materials too. This is just a random foreclosure complaint that I pulled out of one of my clients' files when I was putting these slides together. I just grabbed one. 90%, literally, of the foreclosure complaints that I see are messed up. They're just wrong, and which means I'm filing motions to dismiss because they didn't do what they were supposed to do. Now let me tell you, again, the first one, let's talk about standing. You see at the very top there, it says GMAC Mortgage. That's the plaintiff. They're the ones that are suing. And then I crossed out the defendant. I don't want to share with everybody what's going on with them. But then if you look in paragraph 2 of the complaint, it says on June 17, 2008, Orange County, so-and-so executed and delivered to Lend America a promissory note. Okay? So you're looking at it, you're thinking, all right, GMAC is suing, but Lend America is the one that they gave the promissory note to, the one that gave them the money, the one that they said was that's what they're going to do. Also did the mortgage with Lend America. Okay, let's go 2 slides. Oh, this one right here, perfect. This is the mortgage, okay? And if you look at, I don't know if you can see it, in about the middle of the page, it says Lend America. That's the mortgage, okay? It's not GMAC, it's Lend America. All right, so let's go back up 1 slide, maybe 2, okay? It says, number 3 says, plaintiff is the owner of said note. Well, how'd they become the owner of said note? And I didn't put all the documents that went along with this complaint. It's a big old thick thing like that, and I don't want to show you all that stuff. But I'll tell you, there's no document showing how GMAC became the owner of the note and the mortgage. It's the same as me suing you for foreclosure. I can go get the stuff out of the public records too and attach it to a foreclosure complaint and say, who knows that they have the right to sue you? Maybe they made it up. Maybe it's a scam. I don't know. But why is this happening? And why is this happening in 90% of the cases that I see? Literally, I'm not making that up. That's how it is. And as an old foreclosure attorney on the other side, this appalls me, frankly, the level of lawyering that I'm seeing right now. And it's because of the craziness of the go-go mortgageers, right? That's what's causing this problem right now. In the old days, back when I did this, I represented SunTrust, among other people. SunTrust would do the mortgage. They'd keep the mortgage. They'd hang on to the documents. You'd pay the money to SunTrust. At the end of the day, you paid off SunTrust. You'd have a mortgage burning party, and everything would be great. You know what? That's not what happened, though, with the craziness of the mortgage years. Instead of Lend America being mortgage company A, and instead of them keeping it, it went to B, to C, to D, to E, to F, and then it probably went to 1,000 people as a mortgage-backed security. And you've probably heard that term put around. And there's some trustee and there's 1,000 investors that own a piece of your mortgage because it was bundled and packaged. So in that trip from A to B to C to D to F to the 1,000 investors, somewhere along the way, the documents got misplaced or maybe never happened at all. Maybe there never was, and what they need to have is what's called an assignment document. That's one way of doing it, saying, I assign my rights to you, B. B says, I assign my rights to you, C. But they were moving so fast that those documents never happened very often. Same thing with the mortgage note itself. The original promissory note disappeared somewhere. Maybe generally with A, maybe with B, maybe with C, but somewhere along the way it got lost. Okay? So that's the problem. Somewhere along the way there wasn't authority given for this company to sue you. All right? Now, if it happens that A is where it stopped, let's say Lind America, and I think Lind America is out of business, as many of them are. If Lind America is out of business and they never gave the right to sue you, that's a fatal flaw to the foreclosure. No one can foreclose on this note if that's the case, ever. Now, I'll tell you, that's rare that they don't ever come up with a document, but it could happen. And you could have a quiet title action, and you could have the house free and clear. Okay? Again, very, very, very rare. So I don't want you all thinking, yeah, I'm getting the house, all right? Because it's probably not going to happen, all right? But that is an issue. Now, I'll tell you also what happens. They make them up. You see this a lot. They say, uh-oh, we got a problem. There's no assignment document. Let's make one up. They'll never know. So I file a motion to dismiss, and all of a sudden, there's an assignment document. Wow, look at that. And then it turns out that it can't be real because the notary stamp would have expired way back. You know, for instance, here, I'll give you an example. There's one that should have been dated in 2000. That was when the assignment was dated. It says the notary stamp expires in 2007. I don't know if anybody knows anything about notary laws. They're only good for 4 years. So that's not possible for them to have dated something in 2000 with a notary stamp that expired in 2007. Again, not super prevalent, but it does happen, okay? So these are the, so, okay, yeah, you know what? You didn't do what you were supposed to do. You didn't make the payments, but they're not doing what they're supposed to do, okay? So just because you feel guilty about not making the payments, don't throw your house away, all right? They may have big problems. And I'm not doing this to get somebody or to give you a free house when you probably don't deserve it because they did something wrong. I have different reasons for this, and I'll tell you about that. Let's go to the next slide.